It is 10 o'clock, and I see we've had more people that have joined us. If you were not there at 9 o'clock, welcome to you all to the CGCSA ENS Africa Annual Conference. The first one that we're doing virtually, and it's very encouraging to see so many people having registered. We're sitting at about 191 at the moment, and I'm hoping that with the numbers, we will maintain the numbers throughout the day. Just so that I repeat what I said earlier on, to say that all the sessions will start on the hour to allow those people that wanted to attend specific sessions to join us. Professor Katz, it's your session now on the Competitions Act Amendment Bill. And I think Professor Katz doesn't need any introduction. You know, we all know Professor Katz as the esteemed chairperson of ENS Africa, specializing in corporate and commercial law, including advising on mergers and acquisitions, competition law, tax law, privatization and deregulation, project finance and non-recourse financing, public sector and private sector partnerships, empowerment ventures, and banking and financial markets. Professor Katz has been involved in many large merger and acquisitions, both in South Africa and cross-border. He's also been involved in some high-profile hostile bids. Professor Katz, welcome to you, and we thank you for taking time to join us from your very busy schedule. So we'll hand over to you to take us through your presentation.
Thanks so much, Naya, and welcome to all participants. So what I'm going to try to do in my allotted hour is to cover the proposed amendments to the Companies Act, and if possible, I'll try and leave time for questions. We'll see how we go, but it's quite extensive, so you're going to have to forgive me. So let me just give you the philosophical background. The proposed amendment has, and if you've had an opportunity of reading the explanatory memorandum, it has three philosophical pillars. One is the ease of doing business. Two is introducing equity in the context of remuneration between management on the one hand and shareholders and workers on the other hand. And three, the fight against money laundering and the financing of terrorism. So on the ease of doing business, I think that it's common cause that a well-drafted, user-friendly, clearly understood legislation is fundamental to the ease of doing business. A second component is the elimination of unnecessary compliance burdens. And these unnecessary compliance burdens not only make doing business more complex and increases the costs of administration and the costs of compliance, but it has another unfortunate side effect or byproduct, and that is that it's a barrier to entry. And it operates in this context most harshly on small and medium enterprise. So on the ease of doing business, I'll take you through quite a significant number of proposed amendments and explain what they are and what the rationale is. The second philosophical pillar is the introduction of equity. And there is a concern, not only in South Africa, but worldwide, of excessive executive remuneration at the top and the significant gap between remuneration at the top of the employment chain as against at the bottom. And the concern here, and as I say, this is a worldwide concern, and read the explanatory memorandum, is that this excessive remuneration at the top and the huge pay gap is one of the important causes for inequality in society. And I think it is common cause that the COVID pandemic highlighted how this operates most harshly on the lower ends of society. And more particularly, is that a concern in South Africa, where we have such high levels of poverty and such high levels of inequality. So there is an endeavor to address this. And when I come to section 30A, I'll elaborate. And then the third philosophical pillar is the fight against terrorism funding and money laundering. Again, this is an international concern, and you will have seen more recently in the press how much South Africa is now under pressure from international organizations to take much more active steps to combat money laundering and terrorism financing. And this is being done in accordance with our international obligations and in accordance with the Constitution. And I may say it follows international trends. And we've been given, I think it's 18 months to get our house in order, with significant consequences to South Africa, provision of finance from international institutions. So the stakes are high here. And the proposed amendments in the Companies Act are only some of the efforts that are being made, and other legislative instruments are addressing that same topic. So against that background, let me start dealing with some of the more significant proposals. The first one is the amendment to the definition of equity instruments, section, let me just turn it up, section 1. There is a proposed amendment. Bear with me just one moment. To the definition of securities. And there's been a problem in terms of the existing legislation, because in terms of the existing legislation, securities are defined to mean any shares or debentures or other instruments. And this reference to other instruments has given rise to significant concerns. What is another instrument? Is a shareholder loan account another instrument? So this proposal to limit securities to shares and debentures should be very welcomed. There is a new definition for the first time of true owner, but I'll come to that when we deal with the proposed amendments to section 56. So the next important amendment is section 16. And all company lawyers in the audience will know that there has been significant uncertainty. When an MOI is submitted to CIPC, what is the effective date of that MOI? Do you have to wait for CIPC to acknowledge it? What happens if they don't acknowledge it? So the amendment now states that when a proposed amendment to the MOI is lodged with CIPIC, then unless it's endorsed by CIPIC or rejected with reasons by CIPIC, it's deemed to have been received on the 10th business day following the day on which it is lodged. So that is the first part of the amendment to Section 16. But if the resolution adopting the amendment to the MOI has its own effective date, then that date would be the effective date, but it cannot be earlier than the expiration of the 10-day period to which I've already referred. So I think that the proposed amendment to Section 16 will eliminate a lot of the unnecessary uncertainty that currently exists with regard to the effective date of an amendment to the MOI. The next significant change is Section 26. Section 26 deals with access to certain records of the company. And this is a very important section in the desire to achieve transparency. And you'll see that there are a number of judgments, including in the Constitutional Court, that when a party selects a corporate form to do its business, it has certain privileges arising from that selection, but certain responsibilities. And there are responsibilities to reduce opaqueness and increase transparency. So the proposed amendment to Section 26, and let me just dispel one, some of the comments that I've seen raised on Section 26 is, why is Parliament going to this problem? You can get this information if someone wants it under PIRE. Now, it's true that you can, but we all know that there are procedural requirements of PIRE that could impede immediate access to the information. And the courts have held in Nova versus Corbett that the right of access in terms of Section 26 is an absolute one. And what is the proposed amendment here? It's twofold. There is additional information that shareholders will have the right to, and that includes the new remuneration report, and it includes the register of beneficial interests. So those two categories are added to the information that shareholders are entitled to in terms of Section 26. But there is another amendment to 26 to reduce the burden of compliance on small enterprise. So Section 26 will only apply to public companies, state-owned enterprises, and certain categories of private companies. It won't apply to companies that do internal financial statements and they have a public interest score of less than 100, nor will it apply to private companies that do independent financial statements and have a public interest score of less than 150. So on the one hand, Section 26 has been expanded by virtue of the increased scope of information, but it has been narrowed in that it doesn't apply to certain small companies. Then there is an amendment to section 30.4, and in terms of 30.4, that is where in financial statements the remuneration of directors and financial officers is required to be disclosed. And you always have to read 30.4 with 30.5 and 30.6. So 30.4 is which people's remuneration must be disclosed. It must be disclosed in respect of directors and prescribed officers, not only from the company in which they serve as such, but in other companies in the group where they receive remuneration. And then section 30.6 defines what is meant by remuneration. So the important change that is proposed in section 30.4 is that the disclosure in respect of directors and prescribed officers must now require the naming of those directors and prescribed officers. So you can't say X, Y, Z. It's the named director and financial and prescribed officer. I am going to leave 30.A, the remuneration report, for a moment, because I'm trying to deal in the first instance with those provisions that are aimed at the ease of doing business. And I come to section 33. And 33 deals with the annual return that must be filed with the Commission. The changes here, there are additional documents that must be filed with the annual return, which includes the remuneration report and the schedule of beneficial interests. That's the increase in the scope of 33, but then there is a reduction, and the reduction is that it will only apply to companies that are required in terms of the Act, read together with financial regulations, to have their financial statements audited. So the amendment to 33 is an important amendment. We now come to another important change, and that is the proposed new 38A. And I'm sure I don't have to persuade company lawyers in the audience that this does from time to time give rise to problems. What is the problem? A company mistakenly issues shares where it exceeds the authorized unissued capital. So that allotment would be void. And there have been various views expressed. What do you do? Does a court have jurisdiction to deal with the matter? And this factor that is not dealt with in the current Act was a pure omission. It had been dealt with in the 73 Act, and it was a pure error in not having it in this Act. So what the proposed 38A will empower interested parties to apply to court where there's been an unlawful allotment to request the court to validate it, and the court, if it considers it to be just and equitable, may do so, and on such terms and conditions as are set out in the court order. So this is, once again, an important change. The next one is to Section 40. And you're aware that South Africa doesn't allow for partly paid shares. In terms of Section 40.1 and 40.2 and 40.3, a company can only issue shares against the payment of the consideration, the issue price determined by the board. Now, interestingly enough, 40.2, and I'm often asked about this, is what limitations are there on the board in determining the issue price? There's no statutory determination, and if the price determined is inadequate, then the only remedy would be for an alleged breach of Section 76. That's the director's fiduciary duties and the duties of care, skill, and diligence. And no third party would have a right, but that is just by the way. So what happens is that there are occasions, and in particular in empowerment transactions or with startups, and the proposed LRT of shares doesn't have the financial wherewithal to pay, there is this problem against the prohibition that you can't issue shares unless upfront the issue price has been paid. Well, an exception to that has been made in Section 40.5, and it's a pity that that exception's not used more in practice, because in empowerment transactions in particular, and in startups where you want earnings, you can use the mechanism of Section 40.5 to issue the shares to a stakeholder. And in terms of 40.6, the stakeholder agreement can provide what rights are attaching to the shares, that they receive dividends, they're entitled to the preemptions. But this is a hugely important exemption, and it's been retained in the proposed amendments, but with one change. Instead of referring to the agreement that the shares will be issued to a trustee to be held in trust, that gave rise to concerns as to whether the Trust Property Control Act would apply, and there'd have to be registration with the master. So the reference to a trust has been replaced with stakeholder, and there's a definition of stakeholder, and trustee is referred to as the stakeholder. So that's a nominal change designed to overcome the arguments that in terms of the existing 40.5, potentially the Trust Property Control Act would apply. But before moving on to the next amendment, I really do commend to delegates here today that they should be using Section 40.5 much more often than it appears to be in practice. We now go to perhaps the most important change on the ease of doing business, and that is section 45. 45 has two components. Unfortunately, the current heading is wrong. Section 45 deals with the prohibition of giving financial assistance, a company giving financial assistance to its directors or prescribed officers, or to directors or prescribed officers of any company in the group. That means its holding company, its fellow subsidiaries, and its own subsidiary. That remains as it ought to, unchanged. The other leg of section 45 is the prohibition of financial assistance intra-group. So companies are prohibited, without doing solvency and liquidity tests and getting a special resolution approval of shareholders within the last 2 years, companies cannot give intra-group financial assistance. Now, I think every practitioner in the room will know that almost every transaction, when a company is getting a loan from a bank, and the bank wants security, and it wants another company in the group to stand suretyship, we all know everything that has to then take place. The one unnecessary provision in section 45 is the prohibition in intra-group financial assistance by a company to its subsidiary. And that could be a direct subsidiary or a sub-subsidiary. So if a holding company owns 60%, even 100% of a subsidiary, it cannot give financial assistance without the solvency and liquidity and the special resolution. So this proposed amendment is designed to extract from the net of prohibition financial assistance by a company to its, I call it its own subsidiary, but its own subsidiary clearly includes sub-subsidiaries. So an important amendment 45, which should significantly ease the doing of business. The next important amendment is to section 48, and that's the buyback. A company, if it wishes to do a buyback, other than a redemption of redeemable shares on the prescribed date, a company the directors can decide under section 48(2) to do the buyback. But then comes 48(8). And if the buyback is from a director or prescribed officer or related party of the director or prescribed officer, then it needs a special resolution. But that is 48(8)(a). Under 48(8)(b), there is the following. If the decision to buy back is more than 5%, then section 48(8)(b) says effectively that the provisions of 114 and 115 relating to schemes of arrangement shall apply. Now, this has given rise in practice to great uncertainty. What does it mean that the provisions of 114 and 115 will apply? Does it make it a scheme of arrangement? Does it then attract the appraisal remedy? I think the better view is that it doesn't make it a scheme of arrangement, Therefore, it doesn't attract the appraisal remedy, but all the procedural requirements of 114 and 115, including the independent expert report under 114.2, must be given. Well, not only are these unnecessary protections, for reasons I'll mention in a moment, but they, in their current form, give rise to huge uncertainty. So what is proposed is that when directors resolve in terms of 48.2 to do a buyback, then a special resolution of shareholders will be required to approve of that buyback if the buyback is from directors, prescribed officers, or their related parties. In all other cases, excluding now two exceptions. One, if there is a pro rata buyback from all shareholders, pro rata to their shareholdings, or the buyback occurs on a transaction on the stock exchange. Now, in those two instances, the feeling is that clearly there is no protection required because it applies equally to all shareholders pro rata, or it occurs in the transparency of the stock exchange mechanism. So this amendment to section 48.8 is also expected to ease the doing of business. One point I omitted to mention is in the pro rata buyback, you still are entitled to the exemption if amongst the shareholders there are directors or prescribed officers or related parties of theirs. So if it's only from the buybacks limited to directors, prescribed officers, or their related parties, it requires a special resolution. If, on the other hand, it is to all shareholders pro rata, then the exemption applies even if there is included in all the shareholders a director, prescribed officer, or related party. Let me now move on. The next important amendment is section 56, but that doesn't deal with the ease of doing business, and I'm going to come back to that, the beneficial interests. Then there are some amendments to section 61, particularly section 61.8, which deals with annual general meetings and the business of an annual general meeting. It now fills a lacuna about the appointment of the Social and Ethics Committee of certain companies is to take place at the annual general meeting. There was a lacuna there, and then the documents that are required to be presented at an annual general meeting now include not only the financial statements and the auditor's report, but also the remuneration report and the register of beneficial interests. Next amendment is to section 72. And 72, as you know, deals with the Social and Ethics Committee. So I said there were three philosophical pillars. One, the ease of doing business. Two, equity and remuneration. Three, the fight against money laundering and the finance of terrorism. Then outside of those three were some extensive amendments to the Social and Ethics report and the some purely administrative dealing with matters relating to the jurisdiction of the tribunal and so forth. So there are some extensive amendments to Section 72 dealing with the Social and Ethics Committee. First important amendment is that it only applies to certain companies, public, statutory, and private, with the public interest score exceeding the prescribed amount by the minister. But then there is specific provision now for an application to be made to the tribunal for an exemption from the provisions of Section 72, from having the Social and Ethics Committee. And by and large, the grounds of that exemption would be that there are other structures in the company that deal with the issues that fall within the scope of the Social and Ethics Committee and are adequately dealt with in other structures in the company, or it's not in the public interest, or the public interest doesn't require. So if there's an application made for an exemption, it's now specifically provided in 72(6), and it's an application to the company tribunal. Then there's a corresponding amendment flowing from that. So a company is not obliged to have a Social and Ethics Committee if it's been granted an exemption, or if it's a subsidiary of a holding company and the holding company has a Social and Ethics Committee which will also deal with the issues relating to the mandate of the Social and Ethics Committee by its subsidiary. Then there are some purely drafting areas. Who appoints or elects a Social and Ethics Committee? When does it take place? Some companies at the AGM, other companies the board appoints, and then there is provision for enhanced content of the report of the Social and Ethics Committee, and then there is provision for a required shareholder approval of the Social and Ethics Committee report, and the consequences, the sanctions of not obtaining that approval, and the requirement of having to engage with shareholders who voted against it, come back, see if you can get shareholder approval. The next amendment that I want to deal with is to Section 90. That deals with which companies are obliged to appoint an auditor. And it is only the proposed amendment to Section 90 is that it's only a public company, a state-owned company, a company that is required to have its financials audited based on its public interest score, or a company which in its own MOI requires it to appoint an auditor. So there's some clarifications to Section 90. Another important clarification is to Section 92. And this deals with the position, which I'm sure you're all very familiar with, is there are certain, now that we've had mandatory audit firm rotation, it requires companies periodically to have another audit firm. But there are disqualifications in Section 92 from appointing an auditor, an audit firm that has performed certain work for a company in the past 5 years. And that really reduces the universe of potential firms that can be appointed as auditors in accordance with the mandatory audit firm rotation. So what's happened is it is proposed to reduce the period of 5 years that appears in Section 92 to 2 years. Next very important amendment is to Section 95, which deals with share incentive schemes. And there's an unfortunate provision in the existing wording of Section 95, which limits the shares that are available for a share incentive scheme to issued shares or shares over which there is an option. And that's led to a lot of gymnastics, unnecessary. And so the amendment is that the shares that will be eligible for a share incentive scheme are shares which are issued by the company or are purchased. Shares can be purchased in the market or from anyone, and this will be really an important change for people who are dealing with share incentive schemes. The next amendment is Section 118. And 118 deals with the jurisdiction of the Takeover Regulation Panel. And that jurisdiction applies to regulated companies in respect of which an affected transaction is being done. Affected transaction is defined in Section 117. Now, a regulated company, that definition has given rise to problems. Public companies, state-owned, and certain categories of private companies. And the existing law, which defines the certain categories of private companies, effectively states that it's private companies where there has been a transfer of more than 10% of the shares in the last 24 months on a running basis. Now, that's given rise to jurisdiction to the TRP, which was never intended, which is burdensome. It's even been suggested it applies when you form a shelf company, so there'll be a transfer almost immediately to the people on whose behalf the audit clerk or a law firm clerk formed the company. It will immediately trigger an application to the Takeover Regulation Panel. The proposal now is the categories of private companies will be limited to companies with more than 10 shareholders and having a turnover and assets of a quantum determined by the minister by regulation after consultation with the TRP. This should really ease doing of business considerably. The penultimate amendment that I want to deal with before coming back to the remuneration report and the register of security of beneficial interest is the amendment to Section 135. When a company goes into business rescue, it enjoys a statutory moratorium. No legal proceedings may be instituted against it. Now let's say the tenant that's been placed under business rescue has a lease with its landlord, and in terms of that lease, it's obliged to pay rates and taxes, water, electricity, etc., to third parties, to the council, to Eskom, etc. And it doesn't pay it. The landlord can't institute proceedings for eviction, and the landlord doesn't want its building to be attached by the third-party provider of electricity, lights, and water rates, etc. So the landlord pays it. The proposed amendment is in that occurrence, when the landlord pays during business rescue, the rates and taxes, etc., payable by the tenant to a third party, the landlord will have a claim, and that claim will be regarded as post-commencement finance. And it really is post-commencement finance in character, but its ranking, it will rank before concurrent, and its ranking with other categories, it will rank after employees, so it will be post-commencement finance, but the ranking is specified in the amendment to 135, and then in 145, a landlord who has a claim arising from this provision will have a voting interest in the amount equal to that referred to in the section. Now let me come back to the other two pillars quickly, and that is the remuneration report, the proposed section 30A. And this has been the subject of extensive debate between business and labour and government in NEDLAC. The principles haven't finally been agreed, and there are at least two that I'll mention to you that haven't yet been agreed at NEDLAC. But what happens here is that a company is obliged to prepare a remuneration report, which includes its remuneration policy and remuneration implementation. It's required to have that report approved by shareholders at the AGM, and at each AGM 3 years thereafter, or if they want in that interim period to make a change, a company is not permitted to make payments other than in accordance with its implementation, with its remuneration report. There is provision for the sanction of the consequence of not getting shareholder approval, and the requirement that in those circumstances, the non-executive directors of the Remuneration Committee must stand down. Now, I readily accept there are some drafting issues here, but I don't want to spend time on those. I want to just spend time on the substance. So the important issues that must be disclosed in the remuneration report is the remuneration payable to the top earner in the company and the bottom earner. And then there is the pay gap. the remuneration payable to the top 5% and the remuneration payable to the lowest earning 5%, and then the pay gap. And then there's also one or two other things. Now, let me just make one point very clear. There is no prescription in the proposals what's permitted remuneration or not. It's regulation by disclosure, not by prescription. And one of the philosophical objectives is called, there are two. Shareholders will now know what these realities are. And secondly, there is what's called the shrinking effect. People are often embarrassed to be receiving such excessive quote unquote remuneration in the context of such a significant pay gap. But that is regulation by disclosure, not by prescription. And there are a lot of philosophical issues that have arisen in this, but I think three of the main ones are, firstly, should the approval by shareholders be by a simple majority or by 75%? If it was 75%, it means that 25 plus 1 can veto the remuneration report. Labour has contended for that, business for the 50%. And then what should be the content of the remuneration for determining those disclosures and the 5% and the pay gap? Business has suggested that it should exclude bonuses, it should be basic salary, and Labour said that it should be whatever is earned. And then the other area is what should be the consequences for non-compliance. And I would refer you in the explanatory statement to the references to the United States, England, Australia. All of those, I think, are significantly more onerous than is proposed in the proposed amendments to the Act. My last one that I want to come back to is Section 56, the beneficial interest, the obligation now on companies to disclose the beneficial interests. Now, this is a concern worldwide in the fight against crime, in money laundering. Who are the true holders of beneficial interests in the company? And clearly, the registered holders doesn't and hardly ever coincides with the holders of the beneficial interests. And how do you determine who holds the beneficial interests? This is a difficult exercise. I'm not suggesting the way that it has been attempted in the current draft is without its difficulties, and I'm not suggesting that it will, without doubt, reveal who the holders are of the beneficial interests, but it is a significant step in that direction, and in doing this, South Africa is following the trend worldwide. So there is a definition in Section 1 of true owner. Now, the true owner, in a nutshell, what it's really saying is that there is a person who really calls the shots on those shares, determines how they'll be voted, determines who gets the dividends. That, in essence, is the true owner. What is the relevance of being a true owner? You are, if you fall within the definition of a true owner, you are then deemed to be the holder of a beneficial interest in respect of those shares. There are a number of other deemed holders of beneficial interest. One is the true owner. There's holding and subsidiary. There's a list in the Act, in the proposed amendments, but all designed to try to achieve a register of holders of beneficial interests that, in terms of the amendment to 26, shareholders will have access to. In terms of the annual return in section 33, that will be included in the documents that must go to the commissioner, and it's got all those consequences. But I'll just conclude on the changes to 56. They are really in line with what is happening worldwide, and South Africa has been put on notice to improve the fight against money laundering and terrorism, and one of the most important avenues of that is who are the true holders of beneficial interests in the company. Now I see I've got 2 minutes left, but I think the success of a symposium or a webinar like this is heavily dependent on people adhering to their time limits. So thanks for giving me this opportunity. Thanks to the audience for listening, and I'll get credit for 2 minutes.
Thank you very much, Professor Katz. That was very, very insightful.